Welcome to the 14th episode of Legal Affairs. I am Stephen Yap. Due to COVID-19 pandemic, we have hardly travelled abroad. Now, Hong Kong has now relaxed its entry policy to 0+3 and people are more willing to start flying. This month, England hosted its annual opening of the legal year of England and Wales. For those not familiar with the legal sector, the opening of the legal year of England and Wales is the most important and spectacular legal event of the year, and many international legal institutions have participated. The Hong Kong Bar Association and the Law Society of Hong Kong have been sending representatives to the opening of the legal year of England and Wales for many years. In the studio this afternoon, we have Mr. C.M. Chan, President of the Law Society of Hong Kong, who recently flew to London to physically attend the opening of the legal year of England and Wales. Now, he will give us more insights on his visit. Good afternoon, CM.
Hi, Stephen.
Hi. So I understand you recently went to London for the opening of the legal year of England and Wales. So I have some questions which I would like to pose. Recently, two Supreme Court judges resigned from our Court of Final Appeal. I understand you have been speaking to some of the English Supreme Court judges, and what are their concerns, and have they raised any concerns?
Before I go straight to answering your question, this trip to London was in fact my first overseas trip as President of the Law Society of Hong Kong, and in fact it's the first time I flew on an aeroplane in almost 3 years. Right. So this is something I would say groundbreaking in that sense that I'm telling the international community that Hong Kong is now opening up. We are back to business. So that I think that message is very important. So going back to your specific question about the resigned judges from our CFA, our Court of Final Appeal, yes, it's correct that two of the incumbent Supreme Court judges from the UK resigned as overseas non-permanent judges of the Court of Final Appeal in Hong Kong earlier this year. Again, I didn't have an opportunity to discuss with the gentlemen themselves, but if you look at their statement when they resigned earlier this year, they actually said that Hong Kong Court of Final Appeal maintains its international reputation. It's still internationally respected as a independent judiciary. So notwithstanding their resignation, they actually said that they are supporting Hong Kong's court's independence. That's number one. Number two, I tend to focus on those remaining as overseas non-permanent judges for the Hong Kong Court of Final Appeal. There are 5 UK judges remaining, and 5 of them actually issued a joint statement again earlier this year, confirming their support to the Court of Final Appeal and the system of the overseas non-permanent judges. So all in all, I think the message is quite clear. The rule of law, the judicial independence in Hong Kong is still intact, and this is the main message I tried to deliver to the international legal community when I was in London last week.
Right, okay. So to your knowledge, have many of those judges who were sitting on the CFA read any of our judgments on national security? And do they still remain concerned?
I think for the judges themselves, of course, I have full confidence that they are well versed with what's going on in Hong Kong, the rationale behind NSL and all that. I'm quite sure they are very highly respected and competent judges. However, my concern is those who are not fully familiar with Hong Kong's situation. I did actually meet with some of the bar leaders of other law associations from around the world, and through my discussions with them, I don't think they fully understand the contents, number one, of the NSL, number two, the rationale behind enacting NSL. From their simplified views, they would simply jump to the conclusion that, okay, NSL was enacted by National People's Congress Standing Committee, and then to be applicable in Hong Kong. The one country, two systems is no longer there. So Beijing is now enacting law for Hong Kong directly, without consultation to Hong Kong population. So from that very simplistic view, they said this is in breach of the one country, two systems concept. And of course, I explained this is entirely wrong, because under the Basic Law, we have a well-established mechanism allowing national laws to be applicable in Hong Kong through Article 18 and Annexure 3 of the Basic Law. The NSL was not the first time a piece of national legislation to be applicable in Hong Kong. So I try to explain in the technical terms, and obviously more often than not, if they're willing to listen to my explanation, they tend to agree, oh, there's a legal process. So from a legality point of view, there's not such a big problem. However, there are other issues that they may have concern. For example, the contents of the NSL itself, the 4 offences of the NSL legislation, whether they are fair, whether they are more very draconian, whether they're in line with international practice. Then again, I need to spend some time, if they're willing to listen, to say that, okay, they are more or less in line with international practice. And in fact, under Articles 4 and 5 of NSL, the 2 international covenants on human rights are expressly incorporated in NSL. So after my explanation, they seem to understand more. But again, going back to your specific question, whether they have read the judgments, I doubt very much, apart from the really expert on Hong Kong. The vast majority of the people, including the legal profession, they haven't actually read, number one, the NSL, they haven't read it. Number two, they haven't actually read any written judgments from Hong Kong, I'm afraid.
So, I mean, obviously following on the Western media and some UK politicians do not think positively about Hong Kong. So in this aspect, how do we try to improve it?
I think this is a very relevant question, Stephen. The important thing, of course, is for us, for people like me, representing the law society and representing the legal profession, to go out more, to explain the situation, the real situation to the international community. In many of my speeches, I always emphasize that I'm not from the government. I do not represent the Hong Kong government or even the central government, of course I'm not. But I'm simply trying to express an objective, genuine situation in Hong Kong, and let the audience decide whether whether Hong Kong has no more freedom of speech, or all the freedoms are now being curtailed. So I'll let the international community do their own due diligence.
Right, okay. So NSL cases take time to reach trial, and how can public expectation of swift justice be met? That's something one would always tend to ask.
Yeah, again, Stephen, this is one of the attacks by the West, and to a certain extent, I fully understand why. There's a famous saying that justice delayed, justice not done. This is important to have a swift and efficient criminal justice system, especially under NSL. Some of the accused are being held in custody for a long period of time, especially for those who have allegedly committed non-violent crime. This is actually causing some problem if they are being detained for a long period before trial. Because of the system in Hong Kong, because of the backlog, I honestly don't think that the government is doing it deliberately, just that the process does take a long time. And I definitely urge the government, the prosecution, the judiciary to find ways to speed up the trial. That's important. But more importantly, I think from a defendant's point of view, is whether there is a fair trial. Whether when they really finally appear in court, whether there's a fair process, the judge being independent and his case can be heard from both sides, prosecution and defendant side. I think that's actually the bedrock of our criminal justice system.
Thank you, CM, and That's the program for today. Thank you for watching Legal Affairs. See you next time.